All right. So the bottom line of yesterday is we were saying, uh, in a nutshell, is that we were talking about a case of, do you need the animal as evidence of, just like you would need a weapon as evidence. If this animal is a damager, do you need it as evidence in the court? According to Rav Shimon HaTimni, you do. According to Rabbi Akiva, it's fine that there are witnesses that have seen the event, and that would suffice. So we basically said, well, at the end of the day, with a tum ox, you're using the body of the attacking ox in which to pay the damaged party. So if the ox is put to death and stoned, the damaged party doesn't get sorted out here. If it's a muad ox, why should it affect things? Because you're paying from choice property. And we're saying, well, there is a problem, because if you hold according to Rav Shimon Timni, then you would need the ox itself to appear in the courtroom as evidence. Whereas if you're holding by Rabbi Akiva, then you don't. But then even according to Rabbi Akiva, you'd say, well, this Brysa has to have a problem with him, because otherwise, how would he answer? And the answer is very simple, is that the owner fled. And then the Gemara says, well, if you have that owner that fled before you can't even try the capital case, never mind the monetary case. So what are you talking about? So you're saying no. The owner actually only fled when he realized he was going to owe a fortune of money. But what happened is, when that ox murdered somebody by hitting him, and it was a muad ox, the first thing that the community did was seize him and grabbed him. It says, no, pal, this ox has been causing damage a long time now. It's killed somebody. And they basically put him in a holding cell until the trial. So in that particular case, he has to appear in court. And then there's the capital case, and there's monetary cases, and costings are piling up. So we're saying that if they try the monetary case first, they have to, because that way they could get money. If it's a capital case, then you can't. But then they're saying that basically, well, why can't you? Because you're not paying from the body of the damaging animal. The reality is, even according to Rabbi Akiva, that where the animal doesn't have to be present at the court case, the original owner does. And we're saying here, if he absconded, then they wouldn't have a court case at all. So what do you mean as far as that's concerned? So they're saying, look, it's a case where he did appear in court, but now that he has to pay for monetary damages, he's disappeared, and he's taken his assets with him. So the suggestion is, can you maybe, if you haven't had the capital case yet, work the animal so that the damaged party can at least get some use out of the animal if there aren't any other assets. And the same thing if it's a tum, because you're paying from the body of the attacking animal. So if it's a tum, you can't, because to work the animal is considered a different category of almost a choice asset. It's not paying from the gufa if you're using the labor. As far as muad is concerned, you probably could before they destroy the animal, because it's the equivalent of paying from choice property. And that's how we ended up yesterday from Rav Murray, the son of Rav Kahana, that tells us that plowing is considered choice property of the owner. In other words, it's other assets, and it can't be used to pay the tum. But if the owner absconded, it can at least use its labor to pay the muad before that animal is given the death sentence. So now we're discussing a related issue, because the whole issue came out because we say, look, do we need the animal to judge it as a damaging animal, like a weapon that caused a death to a person, or almost a tool that damaged another ox, because there was a murder and there was a damages action? So the bottom line is, the Gemara is asking now, today, is an assessment performed for damages, or is an assessment not performed for damages? Okay. In other words, we know that if someone either personally or through his property damages another person or his property, you've got to pay. But the Gemara is basically finding out whether the court must first assess the instrument of damage to determine if it was capable of inflicting harm. Now, we know in cases of a capital case, according to Rav Shimon HaTimni, that you do need the weapon assessed in the courtroom. According to Rabbi Akiva, as long as the witnesses saw the weapon, then that would suffice. So we're saying, what in the case of where it's not a murder, it's actually just an assault, or it's damages to property. So we're saying, is there an assessment? So it says here, do we say that it is for killing that we perform an assessment, determining that through a blow with such an instrument the soul leaves the person's body? In other words, a person can be killed, while through a blow with such an instrument the soul does not leave. So therefore, that's a case of damages. So the person's maybe got permanent damage to their body or temporary damage. But do you have to have the same criteria to attribute the attack to a specific instrument? And you need to measure that instrument to see if such a size instrument could have done that damage. Perhaps we say there's no difference. And at the end of the day, if you're doing an assessment for a murder case, the court process should be the same for an injury case, because it says in Numbers chapter 35, verse 17, regarding the death penalty for killing a person, we know. It says, if with a hand-sized stone by which one could die, did he strike him and he died, he is a murderer. So obviously that implies that you can only be liable for murder if the instrument was big enough to have reasonably inflicted a fatal wound. And we also said it depends where he was inflicted. If he was stabbed on the toe with a brick and he had a heart attack, well, you can't hold somebody accountable for murder, because it's not like you were hitting them on the skull. It's a very, very different case. Or perhaps we say regarding an injury that even though the instrument should not have caused such damage, damage is still liable, because sometimes damage can be caused through the smallest of implements. So we're saying, bottom line, do we apply the same laws of damage that we do for murder, that you use an assessment for damages? So it's going to propose an answer from a particular Mishnah. This was a Mishnah we did in 50b. So it was talking about a boar. So classically in Shmot, in Exodus chapter 21, verse 33, it says, if there's a pit in public property and the animal falls into it and dies, the digger is liable. But a boar, in terms of the halachic biblical definition, is round. But the Mishnah talks about anything in Daf 50. It says basically a tolda of boar could be a rug that you left in the road and somebody tripped over it. Or it could be an excavation, that could be a ditch, a trench, a pit. It doesn't have to be around a hole. But the bottom line is as follows, as we say, look, with regards to a pit, guys, I'm testing you. What was sufficient depth to cause halachic death?
10 tefachim.
Perfect. So 10 or more. If the animal dies, there's liability. If the animal dies at 8, are you responsible for the death?
No.
Okay.
No.
And Arthur asked a good question then. He said, well, do you get off scot-free? And it was a question that bothered me. And no, you don't. You're only liable for damages. So what does that mean? Is that if the death of the animal would have a higher implication of cost than damages, then you would only have to pay the damaged portion. So I remember that was a good question, mate. So basically we're saying that any excavation that is sufficient depth to cause death, right? It's 10 tefachim deep or whatever, obligates the digger. So if any of the excavations was less than 10 tefachim deep, an ox or maybe a donkey fell into it and died, the digger is exempt. When we say exempt from the heavy payments. But if the animal was merely injured by the fall of it, the digger is liable. Okay, so what the Gemara is trying to propose here in very complicated language is it's stating that basically that the digger is liable for an injury resulting from a pit shallower than 10 tefachim. And it's suggesting, is it not, that the Tana is considering pits from a low depth to a high depth? What are they basically saying? So in other words, from a depth of 1 tefach until 10 tefachim, there's no liability for death. But for damages, there is liability. So we see from this that damages, there's liability for any impact, therefore that we do not perform an assessment for damages. So what it's basically saying is, since the Tana stated that the law of liability for damages categorically is from 1 to 9, and it doesn't differentiate between debts, it's implied that liability is the same for all debts. And what does that mean? Is then therefore they don't assess, what do you call it? They don't assess the pit for damages and discern between the second tefach and the fourth, meaning there's no assessment for damages. They're trying to use this Mishnah as a proof against the fact that we assess for damages. So guys, what do you think about that? Can you think of that? It's correct, it's not correct? Yes, no, why? What do you think?
No, I think you still need to. I don't think it's a proof that that you don't have to pay damages. I don't think it's a good proof.
No, they're not saying you don't have to pay. It's exempting you from damages. What it's saying is that they're not measuring the instrument of death by the depth. Meaning, if it's up to 10, you're liable for damages. Therefore, they don't do an assessment for damages.
Yeah, sorry, yeah. So I was on the wrong thing. Yeah, sorry. So on that, yeah. So the two tie up there, but so you're saying that they don't have to. That's why they don't have to check the instrument at all of
So
what caused the
this
death.
is a proof that there's no assessment for damages, because as long as it's under 10 tefachim, you pay for damages. They don't say, well, this is the rate you pay for 2 tefachim of damage, and that's the rate you pay for 7. Because the pit is described as an instrument for death or injury, just like an ox, just like a brick, just like a baseball bat. It's got an impact, whether you swing a bat and connect somebody and you assault them, or you brain them and then they're dead. Either way, it's a weapon. The bore is a type of passive weapon where the person falls from a depth into it. So it's saying that for death, we do an assessment, because we know from 10 tefachim up, there's an assessment to know if you're liable for death, if it's 10. But up to 10, we know that you're liable for damages, but we don't discern whether the pit is 2 tefachim or 5 or whatever. Still pay for damages. Therefore, it's wanting to prove there's no assessment made for damages. What do you think of that? Yes or no?
It sounds decent. I'm just trying to think. I mean, it sounds very clever because they're both instruments. I'm just trying to see if there's any flaw in it. There must be, but otherwise it sounds good.
Okay. Arthur,
but there obviously is a flaw somewhere, but I'm just trying to work it out. What are the other guys?
Right there. Are you talking about why they don't do an assessment if it's...
Okay, so the whole argument up until here, it started with saying, listen, when there's a capital case, it was talking about judges that witness a capital case. Can they be impartial and judge the case? We learned that they can't be witnesses and judges. You can't be both. But if you choose to be a witness, there are 5 judges that see a murder. 2 can be witnesses and 3 can be judges that take testimony of the case. Okay, before it goes to Sanhedrin of 23. So there's another argument that says that those who witness cannot be objective and they need to recuse themselves. Okay, and then the whole thing with Rabbi Shimon Tamni and Rabbi Akiva said that basically, well, what happens if the judges see it in the court? Rabbi Akiva says they have to recuse themselves. So you can't actually see it in court. And then it says, well, what happens? Do you see the weapon in court? And the bottom line is we've gravitated towards the fact that the most Rabbi Akiva and Rav Shimon Tamni both agree that the witnesses for sure have to view the weapon of death. Okay, whether the court does, Rabbi Akiva says no, because you can't necessarily recreate that situation in court or have that piece of evidence in court. Why? If you push somebody off a building, then what are you going to do? Bring the building to the court or take the whole court to the building? That building could have been demolished. So you can't take it to a ridiculous point. You've got to basically rely on the witnesses, and that's good enough. Whereas Rav Shimon HaTemimni says no. So with the previous Gemara, it says, listen, an ox that killed a person and then inflicted injury on another ox. If you kill the ox, even if it's muad, you can't try the mandatory case because you need the ox in court. Rabbi Akiva says you don't. So then we're saying, well, then try the mandatory case first. And then we say, well, why is this Mishnah brought up? Brisa? Simply because Rabbi Akiva says, listen, it could still work according to him, because if the owner fled after hearing the case and he took his assets, you can't then put the animal to death, because then you can't pay it off the assets if the guy's only assets is the ox. So we're saying, but if you're putting the animal to death, you can't give it over. So maybe get the animal to work. So the whole theme of this is, for murder, you need to do an assessment of the weapon. At least the witnesses do before court testimony. Do you have to do the same in injury? So far, we learned with the case of the ox, it would seem that you do. Can
I highlight one thing? With
Yeah.
the pit, you don't need witnesses, as far as I know. You don't need witnesses. If it happens, it happens. Yeah, you do need witnesses. And I'm just saying, there is a difference there.
Well,
in this.
Yeah, but the argument's gone away from witnesses and gone to the case of, Gavin's absolutely right. We've moved from the case of witnesses to a case of measuring instruments that cause damage or death. And before we had an ox that caused it, and now we're saying a pit. And the reason why you don't need witnesses in a pit is, guess what? People knew I was building a swimming pool. People knew that Levi had an ox and that I did it in a public place. And guess what? Levi's ox is lying dead or unconscious and slightly retarded in my pit. You don't need witnesses. It's still in my pit.
Yeah, that's what I'm saying. There's a difference because of that.
Yeah. But
okay.
that difference doesn't make a difference for one reason. We're asking, do you still do an assessment in terms of damages if it's less than 10 tefachim? And the argument of the Gemara so far is no. If it's less than 10 tefachim, you pay out for damages, whether it's 2 tefachim or 6. You still pay out on the damages. And so far, you guys can't think of a flaw. So let's cover a little bit.
No, but in the pit, you limited to the goof of the body as well. Yeah, you are as well. Same thing.
Yeah.
No, you're not necessarily not if it's muad.
There's no muad with regards to a pit. You always muad for a pit.
No, not for a pit. I'm talking about if you do damages and the ox is muad, then you're not going to you're going to pay full. So it's. I'm trying to find a way. I know there's a problem. All right, help us, Damon.
No. The reason why one isn't on the right track is because the Gemara is going to bring now, you can work it out the other way around. And it says, look, so it's saying you can see that if it's from 1 tefach to 10, you pay for damages. So obviously, they're not using the pit to measure the instrument of damage, because as long as it's under 10, you pay for damages. So the Gemara says no. The Tana could mean the opposite way around. He's considering pits from 10, from a height to a low depth, instead of from a low depth to a height. Because the first argument says 1 tefach to 9 is for damages. 10 and up is death. It's saying the Gemara can look at it the opposite way around with the Tana, going from a high depth to a low. Saying if an excavation is any depth, up to as little as 10 tefachim, there's liability for death. So in other words, you could have it like 30 to 10, and in that case, it's death liability. But 10 is your minimum. So if it's a bit less than 10 tefach, there's definitely liability for damages, but there's no liability for death. Okay? So according to this interpretation, the one who dug the pit is liable because it's his pit, which was slightly less than 10 tefachim deep, but it's certainly deep enough to cause the damage. Okay, so what we are saying is, in that particular case, the Gemara is saying that the Tana could tell you that there is an assessment performed for damages. And in each and every case, we require an impact strong enough for that property to have been damaged through it. So all it's saying is, guys, it doesn't mean that there's no assessment for damages if it's up to 10, whether it's 2 or 10. What it's saying is you're mixing this thing up. There's only 2 categories. There's death or damages. Either way, we do an assessment. The minute it hits from the highest height to up to 10, it's a death case, because that's a lethal pit. Anything from 1 to 9 is a damages case. But in each case, we have to assess it, because naturally the assessment itself will occur from gravity and the fall. So, for example, if you have a poodle and somebody had a lamb chop at the bottom of a pit, and Fluffy jumped down and didn't realize he hadn't taken his Superman cape, and it's 2 tefachim deep, the poodle will break its legs. And the Santon Kugel will sue you for 2,000 Rand. Okay? Well, today with vet bulls, 10,000 Rand. But if Fluffy, the poodle, saw that lamb chop at the bottom and she jumped 8 tefachim deep, even if Fluffy died, you would pay the maximum Fluffy's worth for her damages, whatever Fluffy would be worth, but not that extra higher portion for death. But probably Fluffy would be a little bit more brain damaged than the brain she used to this, that lamb chop was down there at the bottom. So we're saying the very gravity factor means that the more she jumps higher, and especially if her body's position is bad, she's going to create more damage for herself by the more height. So obviously, assessment is made for damages, because the deeper the fall, even if it's not lethal, the greater the damage. There's just 2 categories. There's damages and death. That's it. But it doesn't mean that you don't assess the level of damage. It's not
okay, so now can I just interrupt you for 1 second? Because just now, earlier on, you said that there's no assessment done if it's under 10.
No.
That is what it is.
Yes.
That's what I heard. That's what I thought you said.
Yes.
And then you changed it. Then you said that there is an assessment done. There's 2 categories.
No. So what it said at the top.
I'm a bit confused now.
Okay, what it said at the top, sorry man, there's a thought, is it said, look, it said, come learn the answer from a Mishnah. The Torah specified pit to cause death being 10 tefachim deep. So any excavation that is sufficient depth obligates the digger. If any of the excavations less than 10 tefachim deep, an ox or donkey fell into it and died, the digger is exempt. But if the animal was merely injured by the fall, the digger is liable. So it says, now in stating that the digger is liable for an injury resulting from shallow than 10 tefachim, is it not Tana is considering pits from a low depth to high? In other words, anything up to 10, we see there's damages for liability. Learn from this that we cannot put an assessment of damages. So the Gemara worded it to confuse on purpose to your left, Damon, saying that you pay for damages whether it's 1 tefach up to 10, and therefore doesn't seem to make any discernment. You pay for damages no matter what. So therefore, there's no assessment for damages. But if you look at it, it's not that there's no assessment. It means it's falling in the category of damages. Anything less up to 10 is in the category of death. So it worded it like that to confuse you, to get you to think. And it wanted you just to think, well, listen, it's heart. Saying the same thing, saying that Tana is not seeming to discern death heart either. And the reason why it doesn't, if the animal's dead, is guess what? You pay the value of the animal. If the animal falls from 10 stories, but falls from 30 stories, you're still paying for the full death rate of the animal. The only time you're really seeing a difference is actually damages. The level of damages severely impacted the tefach. So All I'm saying is that the Gemara set it up for one to think like that. It's not our.
Damon, you're cutting off quite a lot. I don't know if it's my side or your side. Are you guys hearing Damon perfectly?
Yeah, I think we are. Yeah, yes. Yeah.
I've got a very bad connection, and also it's raining quite hard here, and I've got a tin roof. So I'm battling to hear properly, but it's fine. Just letting you know. So it's just my side, eh?
Yeah, I think it's a storm, Gav. So do you understand what I'm saying? It's not that I misworded it. They got you into a mode of thinking to say that it's not seeming to discern between different heights for damages, because up to 10 it's damages, and above 10 it's death. So therefore they don't seem to discern in order to make an assessment for damages. That was the proposition by the Gemara.
Yeah.
Do you get what I'm saying? And then afterwards it says, but you can say the opposite way round. You don't discern with death. Anything 10 or more is in the death category. They don't have a problem with the death category because you're paying the full value of the animal. If it's dead, it's dead. It doesn't matter how hard it fell from. But what they're saying is afterwards, if it's in the category of damages, the Tana could argue that you still obviously assess for damages because the greater the form, the more the damage, especially the way the body of the animal lands. If it lands well, it lands badly. So it's implicit. You don't have to say you assess for damages. It's obvious. It just means that if it's less than 10 tefachim, it's in the category of damages and not death.
Okay, I heard you. I heard you. Okay, now. Thank you.
Does it make sense though?
Yeah, no, perfectly. I couldn't hear you at all properly earlier. Now it's much clearer now. Thank you.
All right.
Still raining, so they had a noise, but I did hear what you.
So it's non-conclusive. So the Gemara is going to go with another proposition. Kevin, I haven't forgotten about you. I'm looking forward to
No, it's fine. So death is a different category. If it dies, it's a.
So no assessment for damages there are. It's just death.
It's different damages.
Yeah, it's a different category. So it says that, all right, so what about a case of indirect damage? So you've got a case where battling with the storm here. Can you guys hear me?
Yeah, but you're fighting hard there.
I'm battling a bit because I've got a tin roof as well, but let's continue. I can kind of work it out.
Cat on a hot tin roof. Remember that?
That would be Arthur's. Yes.
Yeah. All right. So it says, come and approve from a brisa if a master struck his slave upon his eye and blinded him, or upon his ear and he deafened him, the slave goes out to freedom on account of these actions. So we know if you knock out a slave's eye or tooth, damage his ear, you have to free the slave. But at the end of the day, if a slave was listening in on board, he was separated by a prefabricated board, and the master damaged the board, and the shock damaged the slave's ear, that he can't hear, or damages his eye, the slave doesn't go out and account for his freedom because of these actions indirect. So it's proposing that not because we require an assessment and we assume that a to the war shouldn't have blinded or deafened the slave. Saying in this case, when it's indirect, and say that unless it's direct, there's no assessment that's needed to assign responsibility to pay for the damages. Because if you could, then you could see if the slave could go free. Right? So even if we determine that a blow on the wall normally would such an injury, the slave would go battling against the feather.
But
so it's saying, I tell you what, this is we're not coming right in South Africa. Let's rather hear Kevin. Israel.
So you but then I think you're not far from where you are. It's gonna say that there's no liability even if the if it led to hearing loss or about if the owner, I think it's, yeah, that's okay. Should I say, okay. Can you hear me?
Yes, you are
trying. We just got heavy rain, both of us, Damon and I. So I don't know if Damon has a hot tin roof, but I do.
And Arthur has the cats. So
I've got a cold, wet tin, not a hot tin roof. Let's see.
But Arthur's roof is hot because it's no, actually yours would be hot because it's more summer for you. Okay. So it says repentance for suspecting the virtuous. It says here, when a person is aware that people suspect him of inappropriate behavior, he needs to make every effort to clear his name. On the other hand, if someone suspected a virtuous person and it became clear that his suspicion was unjustified, he's obligated to apologize to his fellow, even if the latter is totally unaware that he was the subject of suspicion. Additionally, he is required to bless him, as Elia Cohen did to Hannah, whom he had suspected of being drunk. As Elia Cohen did to, after she clarified to him that she was not intoxicated, but rather childless and was passionately praying for a child, he sent her off and blessed her that her plea for children would be answered. Perhaps suspicion of others originates from innate disdain, howsoever unconscious, towards them, and therefore the usual regret and the asking of forgiveness are insufficient for repentance. Restoring of spiritual equilibrium requires more, a gentle blessing from the depths of the heart for the suspected victim as a means of expressing that he truly values and recognizes his virtues. Someone who has developed a jaundiced eye and a cynical approach to people naturally tends to suspect others of wrongdoings. He tends to concentrate on the imperfections and to associate them with undesirable acts and intentions. Therefore, he doesn't realize that he is doing anything wrong. Furthermore, he convinces himself that since he has not acted, just suspected, no wrong was committed, and then there is no need to repent. Finally, attributing evil intent may become second nature to a person who tends to denigrate or disregard others, even righteous people. Cynics rarely heed the admonitions of the Torah and its scholars. Okay, so just one thing I want to add for a minute or two before I've got to...
Just hang on. As far as tomorrow's concerned, Kevin, your friend from the UK.
Yes, is coming.
All right, so tomorrow night we won't do a share. I'm sure you're all relieved.
So, no, but Damon, you explained very well there. So, but just to add to that, I know, unfortunately, you get people who gossip, and even in the film community, this oak's got money, this oak's... I said to somebody the other day, I said, you have to have M&I, and it's very difficult for all of us, for anybody. I'm talking to myself. Hashem's given certain people wealth, and certain things are given to people, and tools that we have to all deal with. And wealth is one of the things that people are given for whatever the reason. And we have to accept it, that maybe we aren't on the same path, or we're on the same level financially as other people. But with M&I, one has to accept it, because
it's not just the money, Kevin. What you are onto the right track, and I thought about what you were saying. Is it's any loss that you have in your life? People that are single and they wish they had Jewish children and a spouse, and would build a bas mitzvah by Israel and do that. And other people have got 7 or 8 brats running around, and they're happily married, and
grandchildren.
And grandchildren. By the time we're looking to get married, their children are married and they've got grandchildren.
Exactly.
Is difficult. I remember Arthur, thank God Hashem showed him a path of caregiving. He's cared after me for all these years. But caregiving where financially from being stressed, he's feeling relief. And it's so funny because at the time, one never thinks there could be a solution. Anything that we have where we panic and we lack. Sometimes a guy cuts me off today, and I'm thinking, I know the guy's got kids and a wife in the car, happily married or whatever, but he's driving like a lunatic and just cuts me in front of me. And my thought comes in my head, a terrible thought, and that thought is, how does an idiot like this merit children and a wife? The oaks are staying. There's some tree producing oxygen for him. Why?
Oxygen thief, you mean?
Did his car, when he cut you off, was it more than 10 tefakim? I just want to ask you.
Yes, it was, and it was worth.
Yes, you could have killed him. You could have
zuz,
taken him out.
and it was worth more than 400 zuz.
You could have absolutely killed him. You would have got away with it. Anyway.
Yeah, but exactly, and I'm saying the oak was driving, and
that's saying, what you're saying is yeah, 100%. But if
terrible thoughts.
No, that's what you're discussing is legit. If you get people who talk about others and they say, I wish I was like this oak or that oak, but sometimes it's with envy and jealousy, and it's I mean, I spoke to a guy a few weeks ago. I went to a certain family for Sukkot in Renana. Okay. I was in Renana. Arthur has moichled me because I never contacted him. Hey, Arthur. I went to a certain family and I told this a guy, and he said, they haven't got any problems. They got no financial problems. I said, don't talk. How do you know they haven't got problems? And they're such decent people. They've been decent to this oak, and he still talks like behind their back like that to them. I mean,
terrible.
It's like they were blessed. So they do a lot of bits. They're wonderful tzaddikim, this family. So that's them, and they're successful. And he talks like this, and he says, but I said, don't. Continuing to think like that, you actually have showing envy and jealousy, and from people should know better.
Yeah,
I mean, it's easy said than done.
They judge definitely at a more stringent level than a secular Jew, without a doubt, because they've got a consciousness of Hashem and they're ignoring it, and that's a problem. But that's why on Yom Kippur, if you notice, all those buzzwords when you do, what's it called? When you're doing tshuva. Yeah, video and all of that. All those keywords, look at those words each time, and you'll say, have I done that? And you've done every single one.
Every one of those.
Everyone, and every single from person's done it. Even if they've only done it like 0.1%, they've done it. Everybody's done it.
You know what I like about the vidui? It's not how many Shabbases you've kept or how much kosher meals. It's your character trait. The whole vidui service is about character. Yeah, I love it. I really, really love it. Yeah. And you shouldn't wait till Yom Kippur. You should go through it, just some of the deeper concepts in the evening and say, did I speak badly? Did I do this? And just think about it.
Or you can just say, I forgive the people who wronged me during the day. Obviously, if Oak tried to kill somebody, it's not say or stole $1 million from him. But I'm saying someone who did something that was not nice. You need to just move on. And I know that some people don't do that, and it's difficult for them. They can't move on, and it's.
You know what? There is a case where there was a capital case where the family forgave